Welcome to Dorsey and Whitney's webinar on Advertising Law Basics, Part 1. Are your ads claims substantiated? I'd like to introduce Charlene Krogh, a partner and chair of Dorsey's Trademark, Copyright, and Advertising Practice. Charlene?
Thank you, Sean. Good morning, or good afternoon, maybe, everyone. Thanks for joining Fara and I for this part 1 of a 2-part series. I think we've decided September may be the time for part 2, so look for more information on that. It will come from Dorsey. Today's program is 60 minutes. Materials and attendance form are available for download. Q&A, please submit your questions via the chat. Fara is going to try her best to monitor the chat while I'm speaking, and I will try my best to monitor for her when she is speaking. Sorry for the fire alarm you might be able to hear. And we hope to get to all of your questions, but if we can't, please reach out after today's seminar. As Sean mentioned, I'm Charlene Krogh. I'm a partner at Dorsey and Whitney. My co-speaker, co-presenter is Fara Sunderji. She's a partner in my New York office, Dorsey and Whitney. We both practice in the trademark, copyright, and advertising group for Dorsey. And we'll go ahead and get started. We have a lot to get through in 60 minutes, so we're going to do our best here to get through it. So we're going to start with the very beginning, the general standard for advertising. So the legal standard is that advertising has to be truthful, non-deceptive, not unfair, and evidence-based. So essentially, advertisers should have a reasonable basis for advertising claims before they are disseminated. A reasonable basis generally means objective evidence that supports any express or implied claim. So what level of proof do you need to support your ad? The type and sufficiency of the evidence is going to depend on the nature of the claim that you're making. So at a minimum, the advertiser needs to have the level of evidence that it says it has. So if it's doctor recommended, tests prove, studies show, you need to have tests, you need to have doctors, you need to have studies. But otherwise, the level of substantiation depends on what creates a reasonable basis for the claim. So we have 4 examples here in this slide. The first one, they go from sort of less specific or strong claims to more specific or strong. So the first is a printer with versatile scanning functionality. Should be reasonably true. Your scanning printer should have versatile scanning functionality. Shirts have a comfortable fit. You should have consumer support readily obtainable that the fit of the shirt is in fact comfortable. Helps control household odors. So here we're getting into a more specific and stronger claim, and this requires a material degree of efficacy. And then prevents odors, obviously a much stronger claim than the first one in this lineup. And you need a study or research studies, that show a near total effect that the product prevents odors. The type of evidence needed also depends on whether the claim is objectively measurable or is based on subjective perception. And this really depends on how an ad claim is phrased. So the 2 here that you see are most effective antiperspirant. So this is a test for efficacy. It's an objectively measurable claim. And then the second one, you'll feel fresh and dry. This is a subjective perception claim. So what you would need is consumer use and perception survey evidence. So you have to determine the express or implied messages that your ad conveys in order to know what type of substantiation is needed. And how do you do this? Well, you analyze the ad as a whole. You want to view the ad in context with everything that it will be disseminated with. So that's pictures. For instance, if an ad appears on packaging, you want to review the entire packaging piece that the ad appears on, not just the ad in isolation. You want to look for implied claims, not just express claims. Keep in mind here that a depiction of a competitive product may actually create an implied claim relative to that competitor's product. So rather than focusing on specific words or just one sentence, you want to focus on everything and view everything in context. Managing risk associated with your claims. So I'm a lawyer. Of course, bullet point 1 is important to me, but I'm sure it's important to all of you as well. You want to involve counsel, inside counsel, outside counsel early and often. Even if counsel has signed off on an ad campaign or a particular claim, if that claim changes by even one word or potentially, the addition of additional imagery, you want to have that ad reviewed again, because it can change the express or the implied claims that are made. It can make it no longer truthful or perhaps deceptive. Another thing you may want to consider is limiting aggressive claims to digital media that can be changed quickly and inexpensively. So here, when you're making advertising claims that are maybe superiority claims, which we'll talk about in a minute, comparative advertising claims, you may want to limit these and not put them on packaging, for example, because if your market share changes, your position in the market changes, or if a competitor product changes, it's possible that your claim becomes not truthful or deceptive. And then be aware of the competitive landscape. Before you make challenges against competitors related to their advertising claims, make sure your own house is in order, because you can be certain that they'll be looking at your claims as soon as you make a claim against them. So let's talk about a specific type of claim. Now we'll talk about comparative advertising claims. So these generally have a higher risk of challenge because you're making a direct comparison between your product and a competitor or multiple competitors' products. As most of you on this line probably know, these are highly beneficial and very powerful claims. The FTC agrees, and I'll read a short quote here, but the FTC says, comparative advertising, when truthful and non-deceptive, is a source of important information to consumers and assists them in making rational purchasing decisions. Comparative advertising encourages product improvement and innovation and can lead to lower prices in the marketplace. So no wonder it's a really useful tool. But generally, again, higher risk of challenge. You want to avoid apples to oranges comparisons here. So you want to consider the most similar variety of your competitors' products when you're making these types of claims. If there isn't a very similar variety, you're going to need disclosures, detailed disclosures, so that your claim, so there's support for your claim. Also, you can't avoid substantiating a claim by simply referring to the leading brand. Your claim must actually be truthful and non-deceptive as it relates to the leading brand in the market. And then, of course, there's an obligation to keep the claims current. So there's an obligation to monitor and discontinue your claim if your competitor's product has changed, if your product has changed, and the claim is no longer true. Generally, there's two types of comparative advertising claims. They fall into two general categories, I would say, superiority claims and then parity claims. So superiority claims are basically claims that your product is better than others in the marketplace. Broad superiority claims like best or largest, there's some other examples here, have to be supported by reliable market data. So if it's broadly phrased, you need to evaluate the product against virtually all the products in the category. The two examples we have here are the most powerful shower head you can buy and the best digital image quality available in the market. Some of you may also remember a T-Mobile, an example of another broad sort of superiority claim was the T-Mobile Best Unlimited Network claim. And that one was challenged by AT&T. I think it was just a few years ago, Fara. I don't know if you remember exactly, but the claim was that they had best unlimited network coverage, and T-Mobile intended the claim to relate to high-speed data. But it was a very broad claim, and the NAD decided that, in fact, consumers could reasonably take the claim to mean that they were superior in really all aspects: coverage, reliability, other metrics, and recommended that they discontinue the claim. So that's an example of a very broad superiority claim. And then finally here, it's okay to claim that your product is better than your own product, but you need to be clear. And this is where words, really matter. So our best ever versus the best ever. Of course, the word "the" there changes the claim, and of course makes you have to substantiate it versus everybody else in the market. So we'll talk about one more example of an unsubstantiated superiority claim. So this is the case of DKB Household, who makes a claim related to its salad spinner. And there's a picture there for those of you who might not know what a salad spinner is, but it basically spins lettuce or produce.
Hey, Charlene, can I interrupt you for a second?
Yeah, for sure.
Just for the uninitiated in terms of advertising law, I thought it would be helpful to just tell everybody who the NAD is. You can see on the slide that that it says NAD after this claim, and Charlene was going to mention this is a case, and she mentioned before that there was another case. The NAD is a National Advertising Division It's a self-regulatory agency where companies can bring claims against one another. It's a pretty fast dispute resolution mechanism. No damages are awarded, and it's purely voluntary. And so a lot of companies use it. A lot of industries use the NAD to sort of push back at each other and test claims. Of course, because it's voluntary, if the NAD decides that your claims are unsubstantiated, you don't have to make the changes. But if you decide you're not going to make the changes, sometimes they refer them to the FTC, which we all know is not voluntary. So it's a good source of case law when you're trying to figure out, if you can say certain things and how the marketplace might react to something and how regulators might react. Somebody asked a question, how much does it cost to file an NAD claim? I don't remember off the top of my head. It's a good question. There are fees involved. The fees are scaled. They have one set of fees if you're a member of the Better Business Bureau and one set of fees if you're not. And then they also scale them based on the size of the company. I'm thinking the maximum fees, Charlene, maybe are, do you think it's $30,000 if you're a very large company?
It's in my mind quite high, actually. And that is the number I remember. I'm actually trying to look it up right now, but I'm not finding it easily. But yeah, that sounds about right to me.
So sorry to interrupt you.
No, that's perfect. And I appreciate that. It reminds me that not all of us have the same bearings on the subject matter. And yes, Fara is exactly right. The NAD also has a database that has very useful information if you're trying to think through, particularly for certain types of claims, what type of evidence or substantiation might be needed or might have been used by other companies and held to be sort of reliable by the NAD for similar claims. So this is an NAD case. This is NKB Household. They have the salad spinner here, which is pictured. The claim is that it removes 25% more water, and there was an asterisk footnote stating average test results versus leading competitors. And that footnote wasn't used in all cases where the claim was actually made. So it was used kind of intermittently and variably. I think on social media, for instance, it might not have been used in other websites. In this case, DKB actually did hire an independent testing lab to do tests for them. This wasn't an in-house test. The testing was done on sponges and absorbent cloth in lieu of lettuce or produce. And there were many reasons stated for why that happened. Suffice it to say, the lettuce would degrade over time if used multiple times. All of you on the line are thinking there's multiple ways to get around that, but in any event, that was the stated reason. They conducted only 5 trials on each of 2 competitive brands, and the 5 trials resulted in variable data. So the NAD ultimately rules and recommends, not rules, recommends that the claim should be discontinued. So one of the issues, as I mentioned, is the testing wasn't conducted on any form of lettuce or produce. The testing didn't represent a typical condition under which a consumer would actually use or interact with the product. And the NAD finds the test conditions have to be relevant to the typical consumer context. So testing on sponges and cloths, not okay. The test results also must be statistically significant. And here the NAD was specifically concerned that the tests only included 5 trials of each product with a wide ranging set of data points. So the sample size here was not didn't reliably demonstrate the differences in the product, the superiority of the product. And then the marketplace superiority claims have to be based on a broad range of competitive products here. And as I mentioned earlier, it wasn't a limited claim in all cases. And the fact that only 2 competitors' products were the ones tested was problematic here. So the second sort of—
Charlene,
yeah.
Charlene, before you switch over, somebody else asked a question about NAD cases. The case results are not available to the general public. The NAD does publish press releases that you can look at, but you have to have a subscription to the database, which I think costs about, I don't know, between $5,000 and $10,000 a year, something like that, to get access to their cases.
You can, though, without access to the database, of course, subscribe. There's various advertising blogs that are quite good and often have summaries of cases that are being issued that are, relevant or maybe critically important. So shameless plug here, Dorsey has such a blog, which I think Fara will mention at the end of the program. But that is another way to sort of gain access, at least to information in a more timely manner if you don't have access to the NID database. So parity claims are the other sort of category of comparative advertising claims. These compare a product to others in the marketplace, but don't assert that their product is better, just that it's as good as the other products in the marketplace. So examples are no other product is better, no other product delivers more. And like superiority claims, these claims they require substantiation, but they just must show that your product operates at the same level and not that it operates any better. So another specific type of superiority of comparative advertising claim, is the #1 brand claim. So according to the NAD, this is a sales superiority claim, and it's widely understood. So a #1 brand claim, according to the NAD, is, quote, widely understood and accepted to mean that the advertised brand, not a specific product, enjoys the highest market share in its category. So to avoid a challenge, you want to have a specific geographic territory, US versus worldwide, or something else, to avoid a claim that's overly broad. Sorry, I skipped the first one there. You also want to specify a basis, sales revenues versus units. So if you're in a product category where the sales price for a particular product varies quite a bit, you might do better to focus on units rather than sales revenues, of course. And then evidence of consumer preference for a product, or that a product is #1 recommended, doesn't equate to a first in sales or substantiate a first in sales or #1 brand claim. And then, like the other claims we discussed, you have to keep these claims current. So if your market share changes, if your position in the market changes, you need to modify the claim or remove it. All right, and then we have fastest growing brand claim, which is another type of comparative advertising claim. So this is another NAD case, Huggies versus Pampers, cute little babies. Fara, I think you have diapers later in the program too, like. Just
yeah, as I mentioned before, some industries use the NAD a lot, and diapers is one of those industries. So there are a lot of good diaper cases that come out of the NAD.
Diapers and incontinence pad cases, I think, are like
yeah.
high on the, which is, I guess, good for the rest of us because they have a lot of like quantifiable percentage type claims and things like that. So. So the claim here, Procter & Gamble brought an NAD action related to Huggies' claim that they were the fastest growing brand in hospitals. They had a disclaimer notice related to the claim that said, based on volume share growth. So Kimberly-Clark is the maker of Huggies. Procter & Gamble is the maker of Pampers. Kimberly-Clark relied on data that covered its own products and basically said in the case that that was reasonable because Huggies and Pampers are really the only two major players in the market. And if Huggies saw an increase in sales or shipping, that must necessarily mean that Pampers saw a decrease. Everyone on the line is probably already seeing some failures with this logic, but that was the reasoning. And of course, also in this case, it's worth noting that there was a database, a third-party independent database that had hospital product information and sales data called the Global Healthcare Exchange that could have been referenced to obtain the data related to really everybody in the market. So the NAD found that this was a comparative sales claim, has to be supported by reliable sales or market share data for the market as a whole, and not just the Huggies or Kimberly-Clark market. So the fastest growing brand is a comparative in nature, and data on competitors was necessary. The NAD also was mentions here that the independent database was readily available and accessible. It had information on literally all of the competitors, so it could have been relied on to assess and make this claim. Also, the Huggies claim wasn't limited to leading brands. So the fact that they were really only considering Pampers in this context wasn't appropriate. They should have included all or most of the competitors in the marketplace, particularly, again, as that information was readily accessible via this independent database. And then the last thing was that Kimberly-Clark relied on an increase in their absolute shipments to support a fastest growing brand claim, which is a completely different metric, of course, than a volume share and growth in sales volume. That was basically what was stated in the claim. So there was a mismatch between the actual claim and the data that they were using to support this claim. So the NAD here recommended that the claim be discontinued.
So Charlene,
yeah.
Charlene, before you move on, we had a question in the chat. How does a company substantiate superiority claims like industry leading or industry best?
Industry leading or industry best?
Yeah.
So those are broad, sort of not limited claims related to an entire industry and an entire category of products. So you would have to actually have data that supports that your product leads the industry. And I think, Fara, correct me if you disagree, that some sort of, I don't know if disclaimer is the right word, would be needed to tell the consumer how you were measuring what means leading. So is it leading in sales, leading in units sold, leading, I don't know, in the US, maybe some sort of geography limitation. But I think you may, if you're gonna have it be as broad as leading in the industry, it needs to have substantiation that shows that you are in fact, as it relates to all competitors, the leading company.
Yeah, I think that the disclaimer is always really helpful there because, you know, one of the NAD's favorite sayings is that the advertiser is responsible for all reasonable interpretations of your advertising, not just the intended message. And so if you have such a broad claim, there could be 2, 3, 4 reasonable interpretations. And if you want to control what those reasonable interpretations are, disclaimers can really help cabin that in, and you can tell the consumer what your intended message is and avoid unintended messages that you'll ultimately be responsible for. So I think that's I think that is really important. And you know, when you're talking about industry best or the leading competitor, you know, sometimes consumers think that the leading brand is one thing when maybe if you really looked at the sales reports, it's something else. It might be the biggest brand, the most sort of recognizable brand, but sales-wise, maybe it's a off-label brand, maybe it's a value brand. And so you can get challenges from sort of unlikely sources when you're looking at stuff like that.
So Fara, sort of picking up on your comment about the reasonable interpretations, I think that, so that reminds me of 2 different cases that turned out different ways. So one was that T-Mobile case where T-Mobile had an idea of what the best unlimited network meant. And the NAD very much found that there was a different more reasonable interpretation of what consumers would think that meant. So a very broad, unlimited claim there. And then there was a case at the NAD related to Bissell that Bissell brought against, I can't remember the company name, but it was about carpet cleaning. And the claim had something to do with, you know, the best or the leading brand in carpet cleaning. And Bissell said, well, wait, the category of carpet cleaning also includes vacuums and not just these like, you know, products you put on carpets and then you scrub the carpet with. And the NAD disagreed and said, actually, experts in the field, which often they rely on, really say that the category of carpet cleaning supplies, really a reasonable consumer wouldn't consider that to include vacuums. So I think sometimes it's also sort of important to think about what experts in the industry might believe fits into a particular category of products and what a reasonable consumer might believe fits into that category. So.
Yeah, that's great. Thanks.
Yeah. Was there other questions, Fara? Is that it for?
Maybe one other question we can talk about, and for everybody, we are going to get to that CLE code slide. Don't worry.
We're making you wait.
definitely. Somebody had asked a question about the general rule of thumb for what constitutes statistically significant, or is it just a case-by-case basis? Yeah, that is a hard question to answer. I think it is more of a case-by-case basis. You have to sort of look at the math that you're doing. Unfortunately, this is one area of law, I guess, unfortunately for me, that does require a fair bit of math sometimes. If any of you know me, you know that I don't like math. But statistics are actually important in this area of law. And when you're making these claims, sometimes you do have to look at what is statistically significant and really go dig into the data. And sometimes you need some help with that.
Yeah, and I think that as we saw in one of the cases we talked about, statistical significance can often hinge on doing the right number of tests to make sure that the data you're getting is reliable and thus, statistically significant. So yeah, a hard question to answer. All right, CLA code.
Sorry, one more question before the CLA code.
That was really neat, Fara.
How often should studies be repeated to ensure a claim is still valid?
I didn't hear, how often should studies be repeated? Oh, that's interesting. That's an interesting question. I don't, again, like the statistical significance. I'm not sure there's an actual number you could put on it, but I don't know, Fara, do you have any anecdotal experience in helping clients with that particular question?
I mean, in that context, and you mentioned it a few times, that your claims have to be current. And so especially when you're doing comparative claims, you need to test your products against the ones that you're comparing them to and make sure that they're current and that the competitor hasn't changed their products. If they change their products, you definitely need to retest. If you've done a comparative test, and you're testing against, competitor A, and they suddenly release a new version of their product before you've released your ad, but you're getting ready to release your ad, guess what? You got to start over. And so you have to redo them. You are responsible for keeping your claims current. Just because you do your claims once, you do the testing, it's statistically significant, it's scientifically valid. Your product doesn't change, maybe it's not a comparative claim. Could you just leave it for a while? Definitely.
I think that this is also where it becomes helpful to be conservative if you're making, for instance, a quantifiable claim. So if your testing shows that a product is 25% more absorbent, let's say, maybe choosing a number that's more conservative than 25%. So you have a little bit of leeway if a competitor does change its products. This is an instance where that may be more helpful. Okay, so I'm going to turn it over to Fara. So I'll monitor the chat for you, Fara.
Great. All right, so puffing. So what is puffery? I'm going to read you one of the definitions that the NAD has written about puffery. They've defined defining puffery as more than an art than a science. A statement is considered puffery when it's overly vague or highly subjective and not capable of measurement. The NAD has noted that claims can either be provable or disprovable substantive claims, or merely puffery depending on the context of the entire advertisement. And so when your marketing folks come to you and say, is this claim puffery? You can give them the great in-house lawyer answer. It depends. A lot of it is done based on context. As Charlene mentioned before, you have to look at the whole ad and decide whether something is puffery. My favorite example of puffery is the best pizza in the universe. What does that even mean? It means nothing. The pizza place on my block is the best pizza place in the universe. It's basically just boasting. How could you possibly prove who is the best pizza place in the universe? You know, if my pizza place made that claim and then they start having next to it, you know, we have bigger slices than the place down the block, or we use fresher ingredients, we don't use anything frozen, well, it starts becoming objectively provable, and maybe it's not puffery anymore. So you start looking at, can you measure it? Can you prove it? What evidence would you need to prove it? Does it relate to specific characteristics of the product? And then humor is super important in this context because, you know, a lot of great ads make jokes and they end up being puffery.
I actually was thinking about naming this presentation the best advertising presentation ever. I don't know if you've ever played the card game Dose, but it's an Uno. It's a play off of Uno for folks out there who play it. But I don't look at the packaging next time you play it. It actually says like it's the #2 game in the world, and there's a disclaimer that says it hasn't been proven at all. All right.
So some examples, and yeah, look, we're back with diapers. They've got some great examples for us. So Pampers Easy Ups, another NAD case. The maker of Pampers used the best way to potty train and the easiest way to underwear, and it was challenged. The advertiser said, well, these are puffery. You can't possibly prove these. The NAD didn't agree. They said, of course you can prove this. If you're saying that the best way to potty train is to use Easy Ups versus other competitive products, you could do some testing. Just because the testing is difficult to do, because you'd actually have to use toddlers, and how could you possibly make a test and use toddlers and use home diaries and ask moms questions? Well, it doesn't really matter that it's that difficult. You could still do it. So it is objectively provable. The easiest way to underwear. What the advertiser said they intended here was that these Easy Ups were actually the underwear, and it was the easiest way to sort of do underwear as opposed to regular underwear. Well, the NAD said that might have been your intended message, but one of the reasonable messages is the easiest way to transition to regular underwear. So they ended up saying that they had to change these two claims. Another NAD case where the NAD did find that the claim was puffery beyond professional results at a fraction of the cost in relation to a blender. What does it mean to be beyond professional in terms of a blender? I have no idea. And if you're walking around saying, I have no idea what that even really means, it's so vague, how could you ever prove it? You know, it's kind of good evidence. You know, oftentimes if you're considering a claim and you're doing puffery, walk around the office, ask other people on your team, ask the marketing folks, ask the in-house folks. You'll get a couple of different reasonable interpretations, and you'll get a little bit of a barometer. A lot of times in NAD cases, what the NAD says is if you don't submit consumer perception evidence, the NAD stands in the shoes of the consumer, and they just make a determination. In court, you'll need actual consumer perception evidence if you want to challenge this stuff in court. But NAD is a faster, sort of simpler forum, and they just sort of usually step into the shoes and do it for you. Next slide.
It's a good point, Fara, that having consumer perception evidence is a way to control how the NAD might be viewing a claim.
Yeah. So another good NAD case. This is a great case. AT&T and T-Mobile. This is another industry that uses the NAD a lot. You get a lot of good claims. Companies in this area, in phones, in TV, internet, they do a lot of comparative advertising. So you get a lot of really good case law out of this. In this case, I really like this case because it really demonstrates the concept that you need to look at context. Context is so key.
Oops, sorry, Fara. Sorry, I don't know what I just did there. I'm sorry. Go ahead.
Oh, no, you're going in the wrong direction. There we go. So the ad claim here is more for your thing, that's our thing. If you look at the billboard, what does that even mean? It's AT&T's logo with the slogan. I have no idea. It just sounds catchy. It's great, cute. It doesn't really mean anything. It's super vague on the billboard. Puffery, great. But if you start putting that claim, that exact claim on an ad, a television ad or a print ad, and you start talking about, we're offering buy one, get one free iPhones, we're doing a TV bundle, we're offering savings, it starts to become more specific and it can be provable. And that's exactly what the NAD held. Look at the context of the claim. Sometimes more for your thing, that's our thing, is puffery, and sometimes, guess what? It's not.
Sorry, Fara, my internet's running slower than yours. Just
that's okay, don't worry. So absolute claims, another type of claim that we want to talk about. These are sort of high risk claims in a way, and for all you in-house lawyers, good sort of issue spotting here. Look at the words that are used in the claim. See if your marketing teams are using absolute type of words. Leak-free, 100% organic, prevents wrinkles, completely silent. There's no wiggle room here. And as Charlene mentioned, you need substantiation prior to making the claim. So what kind of substantiation do you have to prove that your product is completely silent? Does it help reduce noise? Is it quieter than your previous model, or is it completely silent? Does it prevent wrinkles? Does it help with aging? Does it make you feel good? Or is it 100%? And so these are high bars to reach. And just like comparative advertising, these are types of claims that you should really watch out for. Another type of claim that we see oftentimes, they're called establishment claims. It's sort of a fancy term, but it really just means test prove. So if you are, if your marketing team has an ad and you're saying, test prove that our product is leak-free, or test prove that our product is better than our last version. You have to have those tests before you put out the ad. And you can be hauled into court, hauled into the NAD, a regulator can take a look at you and just say, great, show us the tests that you have. And if you don't have good testing, and we're going to discuss in a little bit what that means, good testing, your claim is just going to be false. It's literally false. If you say that you have a test and you don't have a test, guess what? Your claims are false. And so let's talk a little bit about product testing. When you do product testing, and frankly, we could do a whole seminar about product testing, we need to have tests that are done under realistic usage conditions. Products perform a lot different in a laboratory than they do when they're actually used by consumers. I'm going to go back to the diapers example because we're talking all about diapers today. So think about, toddlers when they wear diapers, how they move, how they run, how they twist when they're sleeping. Think about if you're saying that a diaper product doesn't have leaks, it's leak-free. And think about if you tested that product, say, in a laboratory, and you didn't use any human babies, and you just had it sitting on a table, and you had a dropper, and you just put water, and you just moved the diaper maybe with your hand or something like that. It doesn't really estimate actual conditions of a screaming child who runs around your apartment all day long. So not a real fair
This
realistic
feels
use of
strangely
conditions.
close to home, Fara.
Yeah, you know, I'm just making these things up. But so think about actual usage of how consumers use products. A lot of times we get questions from clients about, you know, so we're looking at a competitive product, and the directions say to use it one way, but we all know that consumers use it a different way. How should we actually be doing our testing? That's a really hard question. It actually comes up a lot. And if you have the data to know that consumers use a product one way because nobody reads directions, and we all know that no one reads directions, I think you got to test it the way that it's actually used. And so that's one thing to note. You'd be surprised too, a lot of products and a lot of industries, there are standard testing methodologies out there. You go to labs, you do research, you look at companies that run certain kinds of tests. They have data and standards, and you just have to follow them. It's not that difficult. You don't have to reinvent the wheel. And when stuff isn't available, you have to use a defensible standard. This is not sort of a strict liability situation. You have to have reasonable support for your claims. And the standard of what's reasonable depends on the claim, as we've been discussing all along. But you know, it has to be good. It doesn't have to be 100% perfect. Another question we get from clients a lot is, can we do this testing internally? Do we have to pay an external lab to do the testing? Well, when you think about testing, you have to think about blinding results. You have to think about bias. Of course, independent testing is always better, but sometimes internal testing is okay. There are definitely situations where you can do that. You can blind internally and things work out well. But you also have to consider, if you're doing internal testing, who are the people who are doing the testing? And do they know too much about the product? Consumers, you know, have a baseline level of knowledge, and maybe people who are working at the company have a much higher understanding of how your product works. They know the ins and outs of it. They develop the product. They deal with it every day, and they may know too much to conduct regular testing.
Fara, I'd also jump in just to say that you know, internal testing can sometimes work really well where there is an established industry way of testing certain things. So when we think about, for instance, like shower heads and force testing, you know, and water usage testing, there are established ways of testing those things. And that might be a situation where an internal test may work very well because it's concrete, established, just as an example.
Yeah, that's a good example. Another kind of question we get from clients a lot is about testing. Can we use data from abroad? It depends. And so look at your product and look at consumers. Shower heads and the force that comes out of a shower head, to use Charlene's example, it's probably the same here as it is in Europe. So it probably wouldn't matter where you did the testing. If you wanted to hire an independent lab in Germany to do it, no problem.
Got to make sure the water pressure is the same. That's the only problem.
Yeah, but if you're working on something that has a product that has an environmental aspect to it, that has, you know, human interaction, results can be really different in different countries. If you think about, for example, how people eat, how many napkins they use, how people wash their hands. These are cultural behaviors that can really be very different from country to country. They can also be different in different areas of this country. And when you're getting statistically significant results, you need to make sure that you've got a good population spread, that you've got geographic coverage across the United States. If you're making a claim about everybody in the United States, it's really important to consider. And the final point that I wanted to make about product testing is that make sure your lab agrees with your results and sort of what you're going to say in the ad claim. And sometimes you may need the folks at the lab to back you up if you get a challenge. You might need somebody to be an expert witness. You might want them to testify. Sometimes testing labs don't want to do that, and they put that in their contracts. So it's definitely important to think about these things ahead of time.
Yeah, I would say we've had examples of claim challenges where we go back to the internal lab that ran the claim, and they see the claim and said, well, I wouldn't have put that word in there. That's really not the position you want to be in. So agree with Fara there.
So moving on to another totally different area, dangling comparisons. You see these in ads a lot. We're better, we're more. Kitty litter stays fresher longer. Discover the better taste of Progresso. Better than what? Fresher than what? What are we comparing? And going back to what I mentioned before is that you're responsible for all reasonable interpretations of your ads. If you have a dangling comparison, could be reasonable that you're comparing to the market leader, could be reasonable that you're comparing to the entire market. A lot of reasonable interpretations out there. And if you don't give a little bit more to say what your intended meaning is, you're going to be responsible for a lot more than you intended. And that could be very problematic. So environmental claims. We could have a whole entire, probably multi-hour presentation on environmental claims. And so I am going to go through this super quickly and only give you a tiny little bit of a taste of it. This is such an important area. As everybody on this call knows, consumers are very focused on environmental benefits. Everybody wants to do their part. And so if you have the choice of buying a product that helps the environment, is good for the planet, and costs the same and performs the same, well, which one are you going to choose? I'm going to choose the green one. And a lot of companies are taking advantage of this intentionally. And a lot of companies are just doing it by accident. And the whole area is called greenwashing, if you hear that term in advertising law. So the Federal Trade Commission initially issued what's called the Green Guides in 1992. They were last updated in 2012. They need to be updated again. I know that there have been a lot of calls from industry groups, especially the fashion industry. They really want the Federal Trade Commission to update them again because so much has changed since 2012. If your teams are making green claims, environmental claims, take a look at the Green Guide. The Federal Trade Commission really does a good job in the Green Guides, even though they're outdated, to give you some good examples. They give you real world examples that you can look at and say, hey, I think that our claims are misleading, or I think they're good. Sorry about that. The main takeaway from the Green Guides is that be very, very careful, i.e. don't do it, in making claims that your products are green, environmentally friendly, eco-friendly, because again, you're responsible for all reasonable interpretations of your claims. What does it mean to be green, Charlene? I have no idea. If we're saying that our bottled water is green, what does it mean? Does it mean we use recycled plastic in the bottle? Does it mean the bottle is recyclable? Does it mean that the water was sourced from an environmentally friendly source? It could mean all of those things. It could mean none of those things. And they're all reasonable. So unless you really mean all of them, and you got to sit around and think about all of these things, don't make such broad claims. Really tell your consumers what you're talking about and make sure you have the substantiation to back that up. This is an enforcement priority for the Federal Trade Commission and has been and will continue to be. And so they are really focused on this. And so it's a high risk area. The green guides talk about biodegradability, compostable claims, recyclable claims, ozone safe claims, free of, non-toxic claims. They give you all these great examples. And so it's a really good resource and it's readable. It's not something that's written in a manner that you have to be an expert to read. So I really do recommend it if your team is making these types of claims or considering these types of claims.
Yeah, and Fara, I think you can't stress enough that this is an important enforcement sort of field of enforcement for the FTC, and it's on the radar for the FTC. I did want to mention one question we had in the chat, Fara. So wouldn't most substantiation documents be protected by work product privilege, as they are almost always prepared in preparation of litigation or competitor challenge? And I'll let you answer that, but I think just anecdotally from the experience I have, most of the substantiation documents are not prepared in advance of litigation related to litigation, but more likely just in terms of substantiating a claim before any claim is made by a competitor. But let me know what you think.
Yeah, I'm going to repeat some of what you said, Charlene, because you were breaking up a little bit, at least from what I could hear.
Thank you.
I don't actually think that the timing works out well, because when you are making a claim, you need to have prior substantiation, and if you're having prior substantiation, it's a little bit strange for you to think that you have a reasonable anticipation of litigation at the same time. It would be very strange for you to think that. So yeah, I don't actually think it would be covered by work product. So I think you got to be very careful about that. All right, so let's keep it moving so we cover everything we want to cover. Disclaimers and qualifying language. Disclaimers are super important, as we've mentioned a couple of times here. Qualifying language, it can really help you explain your claim, but it can help you explain a claim, but I think that you have to be very careful. You can't use disclaimers and qualifying language to change the meaning of a claim, to contradict the meaning of a claim, or to make a claim that's misleading. You can't change the meaning of it. So here, this NAD case is sort of like, in my world, it's famous because I really like it and I use it as an example. I don't even know how old it is. It's quite old now. But so Lean Cuisine was saying that their whole line was preservative free, but then they had a little super that said only 80% of the line doesn't have preservatives. That's contradictory, and you can't say that. You can't use the disclaimer to change the meaning of preservative free. Either the line is preservative free or it's not.
Sorry, my internet is moving slowly, Fara.
No worries. So we're going to go over this one kind of quickly. Another problematic use of calculations and disclaimers. Here, talking about kids' yogurts, the claim was made 33% less sugar on the top, front, and back of the product, but only on the back did it have some asterisks and some footnotes. They were very small. As I mentioned to everybody before, I don't like math. And thankfully, the Southern District of New York actually agreed with me in a way here and said, we can't expect consumers to do math. You can't expect them to figure out what 33% less sugar means by having to do math here. And it was really difficult because they were comparing 4 ounce servings versus 3.1 ounce servings versus different varieties, different flavors. some had more sugar, some had less sugar. You were supposed to average them, but consumers didn't know all that. They didn't have all the information. And so the better approach here, what the court ended up saying was, instead of having this 33% less sugar claim, make it 30% less sugar with an asterisk that clearly says every time you make the claim, then the leading kids drinkable yogurt, and that our yogurts have 2 grams per fluid ounce, and the leading kids drinkable yogurt has 2.9 grams per fluid ounce. So it's a really easy basis to compare. Next slide. Go over this one super quickly. This is a Second Circuit case about problematic disclaimers. The basic takeaway of this case is that you need to have all of the information for your claim. The claim here is whole grain. When you see the box of Chexits, when it says whole grain, you think that it's predominantly whole grain. Well, actually, if you looked at the ingredients, white flour is sort of the first ingredient, and it only had a certain number of grams of whole grain in it, and it was farther down the list of ingredients. Consumers shouldn't have to sort of search and look at the back of the box and correct information. No searching should be necessary. It should be upfront. That's the main takeaway of this case. And we'll go to the next one. Let's actually just skip this one. It's another diapers one, but I do want to get to the last topic. So
this one?
The ad. Yep. Just wanted to quickly talk about this area because it comes up a lot, and I think it's super interesting, and I think it's really helpful too. Using reviews and ad claims. You get a lot of questions from clients. Can we talk about our ratings on Amazon? Can we talk about our ratings on this website, that website? And so as an example, we have over 10,000 5-star reviews. So if you want to use claims like this, you have to really think through, and it's a substantiation issue. What type of claim are you making, and what is your data? You need to look at the data. Just because the data is sort of crowdsourced data doesn't mean that you don't have to follow the same standards that you always follow. Look at the reviews. Are they representative? Another, sort of good example of that is, where are you getting the reviews from? If you are only counting the reviews, say, on your own website, who goes to your website? It's probably not a broad spectrum of people. You've got super fans and you've got people who really complain. Maybe those two things cancel each other out. Maybe they don't. You also have to look at reliable reviews. There's a lot of astroturfing that goes on in terms of reviews. And so using verified reviews really is the gold standard. It's not the only way to make sure that reviews are reliable, but you should be using reviews of people who actually buy the products. Another type of ad claim that we get for reviews, people asking questions about, is can we use specific reviews in our ads? What if somebody said this and we want to publish the review in an ad? Well, it's now then you making the claim, you as the advertiser. And so it needs to be substantiated. Best tasting lobster roll west of Maine. Can we prove that? What do you think, Charlene? Do you think it's puffery, or do you think it's provable?
I think it's a little bit of, well, it's pretty specific, but I think it's a little bit of puffery.
I think you're right. So I think we could use it from a ad substantiation point of view, but do we have permission to use it? Did we ask for permission? Is it in our terms and conditions on our website if it appeared on our website? What if it appeared on Yelp? Yelp has really specific terms and conditions about whether you can take reviews from them. You also have a right of publicity issue. I mean, Sandy E, she may be on the line. Do we know that we can use her first name and her last initial? Do we know that there's more than one of her? and people might be able to identify who it is. Some of you may know who it is. And so, you know, there are a lot of issues to consider there. So we are right at the 2 o'clock mark. So just wanted to wrap up. Or I guess it's 2 o'clock here on the East Coast and different times other places. But so we thank you so much for joining us today. This is our first in the series. We're going to do, like we said, our second part probably in the fall in September. The PowerPoint is available for download. And we really encourage you to look at our blog, thetmca.com. We cover a lot of these issues. We keep up to date on a lot of NAD cases and federal cases. Any last questions, Charlene, before we wrap up? I know we're already a minute over, but.
Yeah, let me see. Sorry, I'm can you hear me well? Fara, my internet is shaky right now.
Yeah.
I think we covered the one question that was asked. And there's a few people who have questions about the presentation being available for download. There's a link in the reminder that was sent from events at Dorsey that will have a link to the materials, link to the blog in the chat. Yes, I can send that right now, but it's thetmca.com. All right.
Well, thanks everybody for joining us.
Yes, have a great afternoon wherever you are.